we've calendared this apparently as a hearing for an informal advisory opinion, yet no one has come before this commission and requested one. Your own rules, 4.2, says that it can be requested, but Mr. Highland hasn't requested one. In fact, he previously withdrew it by indicating he's never going to appear again. He in fact hasn't appeared, and now is asking for something different. So I would request that 2015-3 simply be dismissed because no one's asking for an advisory opinion at this point.
You're continuing with your testimony?
I'm not giving testimony. I haven't been asked any questions. There's been very little presented to us to respond to.
Since we are here for an informal advisory, that's the motion, that's what we're here for. We should ask if you want a closed hearing or not before proceeding. I mean, we don't want to ask questions and get a response.
If we're going to move forward with a request that no one's making, do we want that heard in a closed hearing? I guess so, yes.
Then I will move that we move to a closed hearing.
We would do this because of privacy measures. So
Yes.
what are the privacy measures that we're talking about
This
here?
is a personal matter. There may be information about his personal finances. We don't know. Could be it's a personnel type of issue. I think any other county employee, we certainly would have no question of having a privacy. Albeit there's been a trial, there's a lot out in the public.
On the whole, I would have to come down on the other side of that this is sufficiently an issue of public notoriety that having a discussion about how it's going to be handled and the issues associated with it need to be on the record. That would be my view.
Just add to that, I would note that any vote and any decision-making would have to be public, and as would be any written decision.
Anybody opposed? We have to do it again. I didn't have the microphone on. Please say no.
No.
No. And anybody?
After hearing discussion, I'll say no.
Okay. So we have 3 no's and 1 yes. So the motion is not carried.
You know, I'm really conflicted because on the one hand, the petitioner has not submitted anything other than newspaper articles. Generally, you have the petitioner submit evidence. I mean, we're here and there's nothing that's been submitted. What evidence do we have presented by Mr. Highland? And that really makes it complicated for me because on the other hand, the mayor aside, I think our county employees need some kind of guidance regarding using a PCard, and it seems apparent that the issue isn't very clear. And I think it would be good for the board to send a message to say, it may not have been clear before, but hey, from this point on, you shouldn't use your PCard for private use. And if something incidental happens, after being notified in a reasonable time, you need to pay it back. I think we need to, based on both what's in the charter and the code as far as, in essence, it could be seen as an interest-free loan, right? So I think we should do that. But again, we don't have a petitioner. Nothing's been submitted. What are we really looking at?
No, they've asked a question that has to do with, what's the petition. The petition is 2015-03. It was provided April 17, 2015. All of the correspondence that I'm aware of has been provided to the respondent that's associated with it. We've received all of that correspondence as well. Through a series of motions, we have come to this point where we are now considering it in an informal hearing stage. It's never been dismissed. And so the fact that we don't have, well, I'll get to that as part of the discussion phase. And so Madam Chair, I would invite further testimony, if there is further testimony from the respondent's representative.
So I think preliminarily, we object to proceeding without the petitioner being present. We object to a representative of the petitioner being permitted to provide testimony. We object to this board moving forward with an informal advisory hearing without any requests contrary to its rules. If we are having the hearing, and believe me, I mean, if we're moving forward, we're requesting the hearing as well, because we don't agree to this. And pursuant to your own rules, when the respondent requests a hearing and disputes this, then it's to be deemed an investigatory hearing, and the commission needs to take actions to investigate this or accept other information from the petitioner. Vice Chair Goodenough's point is very well taken. We're in a position where we've won a trial. It's been established. The mayor's not a thief. The mayor's not a liar. And we're moving forward this petition, and this petition is predicated, the first sentence of it says that Mr. Highland cannot abide by the mayor being a common thief and remaining in office. And so that has now been established not to be true, and we can provide the commission with a copy of the acquittal if that will assist in the decision-making process here. But I think we're not following the rules of the commission, and now we're being asked to respond to some somewhat specific, although very unparticularized allegations. There's newspaper articles which, during the course of the last 18 months, have been hit and miss at best. There's been wide misinformation. I mean, at this point, Hawaii News Now still hasn't been getting it right. So we're in a very difficult position. So we don't even know exactly what conduct we're being accused of so that we can respond properly. So, you know, we object to the process. He's been acquitted, and there's been really no evidence presented to this commission that any ethical violation has occurred. And in addition, the ethical violations that are alleged by Mr. Highland, I think the first two clearly cannot form the basis. You know, one is the enactments and policy section. And finally, the final allegation, and like I said, I'm reluctant to respond to it because I don't even know exactly what the allegation is. You know, it seems to be this general broad that he did wrong. And that's a very difficult thing to respond to in a formal setting. No court of law would let that go forward. And I respectfully submit that this commission shouldn't either.
To me, the allegation is clearly stated in petition number 2015-03 that the alleged violations are section 14-1, section 14-2, section 14-4. So I don't see where there is a confusion about what the allegations are. That's just me. You know, when we heard this earlier, we wanted to make sure that the mayor got a fair trial, and so there was the reason to postpone that based on that opinion. But the issue had been out for quite a while. We know what the issue is, which is a violation of specific sections of the county charter. And here we are now to discuss that. I mean, I feel very strongly, you know, that we really accommodated the mayor at a very high level to make sure that he would have a fair trial, and I think that has happened to the best of my knowledge. And as was pointed out, there's a difference between a criminal trial and ethic violation. So I don't see why we should not move forward. If you're finished with your presentation, with a discussion by the board.
You know, an individual shouldn't be put in a position where you have to choose between your rights between a fair trial and your rights to be fairly treated in an administrative setting. Usually when an accusation is made, it's not just the accusation, but somebody comes and tells you, these are the facts that support this allegation. And in this case, there's newspaper articles. And respectfully, you should not rely on that. You should either expect evidence to be presented by the petitioner, or if you're gonna go into an investigatory sort of mode, then this commission should have investigated. But, you know, we shouldn't have to choose about who we want to be treated fairly by. If the commission wants further information from us, we can get you the transcript of the trial. We've ordered it, but, you know, it's pretty fresh, so we don't have it.
Yeah, we understand that. Thank you. We already tried to get it as well. Thanks. Any further comments?
I mean, I'm looking at the original petition, and I will admit, I mean, it's saying he wants him removed from office. It has been our practice, though, to treat these petitions as a request for an advisory opinion under Rule 4.2. I just was asking our counsel, or Mr. Adams, as to, you know, Mr. Adams made the comment earlier that the procedure is we first have to have this advisory opinion, an informal one, and then after that, a formal opinion it can be requested by the respondent.